Thank you, everyone, for coming tonight to the Second Annual Symposium on Corporate Oppression. Last year, we had the first Annual Symposium on Corporate Oppression here at Forts Legal, who have been kind enough to host it for the second year running. And I suppose that would make next year's the third annual symposium, which we fully intend to have. Although I have to confess, the State Bar of Michigan has informed me that I shouldn't be calling it a first, a second, or a third annual because it implies a commitment to keep doing it. I'm all in, and I love bringing people together to discuss this, what I think is a very interesting and exciting area of law. I find it fascinating to examine how human beings form and also destroy their relationships. And these cases, these business disputes, they can be even more acrimonious than divorces. Because at least in a divorce, presumably, at the beginning, people actually loved one another. In these cases, it tends to be about power, greed, fear, and loathing, which is fertile ground for us litigators. And Judge Yates may have said it best. Judge Yates, he came tonight, right? Hopefully, because he's going to be speaking with us. Judge Yates may have said it best in one of the recent opinions that he penned, where he said, "Not since Cain and Abel have siblings battled with the ferocity of the Peach family." And that was an opinion he wrote in, I think it was 2016 or 17, and congratulations, because it was affirmed on appeal. I know. And I read the opinion, and it is true with the ferocity that it was litigated. So I'm happy to report, also in looking out here tonight, that we've actually, from last year, from the first annual symposium, we've increased the attendance over tenfold, believe it or not, tenfold. Last year, the speakers actually outnumbered the audience members, and it left us with a lot of extra food at the end of the night, which surprisingly, as I hope you would agree, it kept quite well, because we reheated it and reserved it to you this year. And the year before that, actually, believe it or not, I did a program in Grand Rapids over at Barnum on corporate structuring and succession planning, and only 2 people showed up, and one of them actually left early. And they called me to apologize and explain to me how hard it is to skate out of a program where only 2 people are in attendance. So tonight it'll be a little bit easier if you want to sneak out the back door. So it takes the pressure off when nobody comes to your programs, but it's a lot more fun and interesting when there's more people who know what they're talking about in attendance. And when I saw the roster of lawyers who are in attendance tonight, I was excited, and I thought I saw a lot of names of people who know what they're talking about in this area of law. And I thought that the most appropriate format would be one that strongly encourages and facilitates audience participation. So in that regard, I would encourage you to speak up and not hold back. And in that regard, remember, there's really no dumb questions, but there are dumb answers. So feel free to ask them, and if you feel that the answers aren't smart like they should be, call us out and chime in, disagree, interrupt. And this is really intended to be a format where we can learn from you as much as you're learning from us. So that said, I'm very excited that we're gaining some traction over here on the west side of the state with these section programs, because in the past, historically, they've all been held over on the east side of the state, and there was a decision made to duplicate in Grand Rapids these programs on the west side of the state. And the reason that I think it's so great is because lawyers from both sides of the states, which seem to be somewhat far apart, can actually get together and hear each other talk and know one another, and hopefully do business with one another. So we have some really good speakers lined up tonight to talk on the issue of corporate oppression and fiduciary duty. And to get things started, my colleague Elyse Palombit and I will spend about 10 or 15 minutes going over some of the interesting business court decisions from 2019, just to give a brief overview of how the trial courts, where most of us are practicing, are dealing with oppression and fiduciary duty issues. And during this segment, if anyone has any experiences or insights with respect to cases they're handling or decisions they're getting from judges or the application of the various precedents or recent decisions that have been issued and how they're being applied in the trial court, don't hesitate to chime in. We want to hear from you. As you know, there have been several important decisions in the last couple of years, which have been defining the contours of the oppression claim. From Frank v. Linkner, Matagula v. Taub in the Michigan Supreme Court, to Castle versus Johan, and most recently, Franks v. Franks in the Court of Appeals, which is the first published opinion which is offering serious guidance on some of the substantive areas in oppression in a long time. And it's interesting to see how practitioners and courts are grappling with these precedents and applying them in the cases that are in the trial courts. And I'm interested in people's opinions on whether these decisions are actually narrowing or broadening the statutes or bringing clarity to them or actually confusing them, and how there's an interplay between those precedents and the amendments that are pending or looming over us with respect to 1489 and the LLC corollary to 1489, and whether those precedents will actually guide those amendments. So again, if anybody has any insights into how those amendments are playing out and the discussions, I know there's a committee that's been formed, feel free to let us know. So we'll hear from Paul McCarthy from Rhoades McKee, and he's going to be presenting on one of the more problematic concepts in the oppression body of law, which is under what circumstances does the termination of a minority owner's employment constitute actionable oppression? Whether termination of employment constitutes actionable oppression has been a tough question from the beginning, when the Court of Appeals in Franchino versus Franchino, way back in 2004, said that the termination of employment is absolutely not actionable oppression, because the terminated employee's shareholder didn't suffer injury as a shareholder. Those are important words, as a shareholder. What is injury as a shareholder? Because under the statute and under the precedents, that is all that constitutes actionable shareholder oppression. Well, that absurd decision, which held that a terminated employee whose only remuneration from the company came through his employment with the company didn't constitute actionable oppression, that triggered the 2006 amendments by which the legislature amended the statute to clarify that there are certain circumstances when termination of employment will constitute liability under the statutes. And Paul is going to tell us exactly what those circumstances are.
That's funny.
Well, in your bio, Paul, on your website, you quote Galileo, and you state that all truths are easy to understand once they are discovered, and the point is to discover them. So I'm hoping that you'll help us discover these truths tonight.
Me too.
And next, we'll hear from Ian Williamson. And I worked with Ian for about a decade and was his partner for much of that time. And I can attest that he's one of the top litigators and scholars in the field of corporate oppression. So you should all look forward to hearing from him. And he's going to be presenting on the business judgment rule. And I know we all talked about the business judgment rule in law school, and I didn't understand what it meant. And I still really don't understand what it means. And where it gets even more confusing is in its application in the oppression context. and it has a very nuanced application in this context. And as with the employment termination issue, it is often inconsistently and incorrectly applied in the trial courts and in the Court of Appeals, in my humble opinion. And Ian will discuss the effect of the Franks v. Franks case on the business judgment rule. And that's the most recent precedent out of the Court of Appeals on this issue. And it's an important case, and it's an important case with respect to how the business judgment rule, which in many respects is an absolute shield to liability, plays out in the world of a very broad and remedial statute, which seems to conflict with the business judgment rule. And next we'll hear from David Hansma from Seyburn Kahn, who I also had the pleasure of litigating with for the better part of a decade. And he's going to take us on more of a deep dive into that Franks v. Franks precedent with predictably defense-oriented interpretation of the case. And Dave, notwithstanding your very strict constructionist and pro-defense viewpoints, I do still love you. I'm sure you'll share some of your awesome insights into this important precedent, which everyone should read and reread very closely, because this decision will be guiding the application of the oppression statutes like no other precedent in recent years, and in my opinion is more noteworthy than even the recent Michigan Supreme Court decisions on these issues. Lastly, we'll hear from Judge Christopher Yates of the Kent County Business Court, who will offer his perspectives from the bench. Judge Yates writes some of the most poignant and well-written and interesting opinions out there. I encourage you to read them all, start to finish. And I was excited when he agreed to speak at this year's event, because at last year's event, he shared some very interesting and, like I said, poignant viewpoints on this area of law, and also on how the business courts are applying these precedents. And I wanted to thank Forts Legal very much, Sean Fitzpatrick and Colin Rhoades and their team for hosting this event this year. You guys do a great work, and you have beautiful space here, and we appreciate it very much.
Hey Mark,
yeah.
Welcome to West Michigan. It's Ritzema.
Ritzema.
Well, like Smith over here.
It reminds me of when I had a case up in, I don't know what county it is, but I had a case that involved a receivership in a place that I thought was pronounced Grand Blanc. But when I said that in the courtroom, everybody laughed. And I was corrected and told it was Grand Blanc. And I didn't argue my case, but I think the French would have pronounced it. So, all right, so Ritzema?
Yes.
Is that right? All right, Ritzema. All right, so anyway, everybody, as we go through this, we have lots of food, lots of drink. Feel free to move around, and don't feel bound to your seat. And don't feel like you gotta listen to just us talk. You can interrupt and let your lawyerly nature shine through. And so we're going to start with Elyse and I. We're going to go over some business cases briefly, and then we'll move it forward. Yeah.
How's the temperature?
That's good.
Thank you.
All right, all right, so we got the Heather Spitzler versus Gerald Spittler case just a month ago in Livingston County Circuit Court. What did they say in this case? Breach of a shareholder agreement, huh?
Yeah, so in this case, the court had applied the holding medical law that breach of a shareholder agreement can support claim for oppression.
Now, this was a case that is a statement from the Matagula decision, and it's not that the breach of a shareholder agreement absolutely does constitute an actionable oppressive event. It's that it can do so, which creates a lot of latitude in terms of how we plead our cases. And what we found when we were looking at these cases was that the trial courts were holding we're denying C8 motions to dismiss cases where the corporate governance was breached and it was pled as such, but then leaving it open to determining whether that actually constituted an actionable oppressive event, which I think creates a difficult situation for a court and for litigators, because on the one hand, you do have a breach of contract, and you're trying to feed it into into a theory of oppression, and it seems duplicative in nature, and it raises questions of whether, if it doesn't necessarily rise to the level of oppression, does it still constitute a breach of contract? And so I think there's a lot of ambiguity in that, in the standard that was set forth in the Matagula case, that the breach of a corporate governance document can constitute an oppressive action. Has anybody had any experience with that issue in the trial courts, or?
I was just wondering, is this a C8 or a C10 motion?
This was C8, wasn't it?
Yeah.
It was C8. So the breach of the agreement is being pled, and the courts are holding that it keeps the claim alive because it's possible that it could constitute an oppressive action. So,
Is there any C10 motions tonight?
we haven't seen any in the business courts.
Yeah, that's not
Yeah. So that's something to look for when you're pleading your case. The breach of these documents usually keeps the claim alive, which, from the plaintiff's perspective, if you beat your C8 motion, that usually creates quite a bit of leverage in the litigation, because then the case goes on for 2 years, and you get to take discovery on it. And so that's, in my view, that's quite a sword, that the breach of those agreements automatically gets you past summary.
Well, I was just going to say, we had this issue in the context of jury demand, and whether the breach of contract claim could be tried to a jury, while the same theory, but was under the statute, it had to be tried only to the bench, and whether the breach of contract claim sort of got swallowed up in the oppression claim. That the court said exactly that. It was all going to be a bench trial, and the breach of contract claim really just got folded into the statutory claim.
Okay, yeah, that's interesting, because in Matagula, it was held that anything related to the shareholder oppression claim is no jury trial. That's very clear.
Right.
But you can ask for advisory juries too. So.
So this case out of Oakland County actually didn't involve the shareholder oppression claim. But here the plaintiff had brought a claim against the defendant for breach of fiduciary duty. And the court held that the defendant was not a member of the plaintiff company, such that he didn't owe any fiduciary duties to the company as a member. However, the court did find that there was a question of fact regarding whether there was a fiduciary relationship between the parties under a partnership.
The partnership theory is an interesting one, because as you see in this case, they're trying to establish that the defense was a member of the company or a member in control, such that the defendant owed a fiduciary duty, and they failed to do that because, as often is the case in these oppression cases that make it, into litigation, the corporate governance is a mess, and it actually amazes me time and time again. Sometimes it's such a mess that we don't even know who the owners are or how much they owe or how much they own. So in this case, the plaintiff failed to establish that the defendant was a fiduciary or a member, and they went to 449.1, which is a great statute when you don't have any other way to establish that there's a fiduciary duty owing to the plaintiff, because the partnership concept is so broad. And I'm not sure if it's this case or another one we're going to cite in a few minutes, where just mere statements that we're partners, which is a term that's used very loosely among business owners, can actually be used under the ban precedent and the biker precedent to establish that there's a partnership. With a partnership, you've got a fiduciary duty. And so we found this case to be interesting because on paper there's no fiduciary duty, but the court held that there was a question of fact on 449.1 that there was a partnership between these people. And what were the facts on this that established the partnership? It was kind of weak, but...
Right, yeah. What the court relied on primarily was the plaintiff's assertion that he had, or the sole owner of the company had made statements in front of the defendant and in front of a third party business associate that the defendant was a partner of the company, and the defendant didn't deny that statement. There also were a few other allegations that the parties had discussed a partnership, but it seemed that the court relied primarily on his assertion that these statements were made and not denied.
Was it an email to a bank rep or something?
That's the next one.
Oh, that's the next one. Okay, but anyway, I think it highlights the importance of disclaiming partnership, which we do see in various contracts, but it's a real dangerous thing to have this. It's not common law, it's by statute, but I think it's adopting common law standards of partnership, but it's a really dangerous thing to have this sort of de facto partnership arise, and as you can see in this case, these poor defendants have to defend this case now probably for another year or so and be leveraged economically with this litigation because he said the guy was a partner of his. So who knows what they intended on the corporate governance, but let it be a lesson. In Days case. Okay, this is a similar case. And was this the one where the plaintiff was trying to establish that he was a member of the corporation?
Right, yeah. So in this case, the court had held that even though the corporate governance documents didn't reflect the membership interest, the court allowed extrinsic evidence to show that he was a member. So this one involved.
This was the email of the bank representative, where he said, let my partner, or let the other member of the company sign the document.
Right, so yeah, what the extrinsic evidence was an email from the defendants to the company's bank referring to the plaintiff as our other member.
I mean, my view is when it comes to the question of whether somebody is actually an owner of a company, the evidence should be very clear and very convincing before you let a member oppression case go forward. But you see, the courts, they're struggling with unclear corporate governance documents, and they're accepting extrinsic evidence coming in as statements as to whether someone owns a company. And there's a lot of different kinds of evidence out there that can establish ownership, like K1s and maybe equal profit sharing and things of that nature. But you know, here we see these things are such a mess that courts are accepting you know, extrinsic statements as evidence of who owns what. So I mean, has anybody experienced any of this in terms of trying to establish through outside evidence whether somebody owns the company or whether somebody's a fiduciary or any of that? All right. Well, it's happening. And it's creating confusing situations.
So here the court had found that the plaintiff had stated a claim for shareholder oppression against the company's CEO, who wasn't a shareholder of the company. He was not the board of directors. But because of his capacity as CEO, he exercised control over the corporation and therefore was in control of the corporation for purposes of the statute.
This is an interesting case because I think it highlights the difference between 1489, is it 4515? All right, well, the LLC corollary, where under 1489, you can sue people who are those in control of the company. They don't have to be members, they don't have to be, or they don't have to be shareholders, they don't have to be directors, they don't have to be officers. They're just simply people in control of the company, which is different from the LLC statute, And in my view, there's no good reason for there to be a difference in these statutes. So when they get around to amending them, it's, you know, the LLC statute requires that you sue members in control. The shareholder, the corporation statute requires those in control. And so here you see somebody who is a CEO, but he's not an owner, he's not a director, but he admitted in his deposition that he had some level of control in the corporation, and the court allowed him to be sued. So, you know, under 1489, you can go after people who don't have an ownership interest, aren't directors, and are involved in the day-to-day operations of the company and exercise some level of control. So it's broader, and it shouldn't be. I think they should be brought, you know, into, there should be some consistency between the two, but for now there's not. So this case highlights that. Wheeler. This case highlights one of the most confusing areas of law in this context, which is you don't have an oppression claim, but you're trying to sue for a breach of fiduciary duty because somebody did a bunch of bad things to the company. I don't know, stole, what did they do in this case?
Basically, the defendant had withheld a bunch of commissions that they weren't supposed to withhold under the arrangement that they had for the salaries. They kind of eliminated commissions, but the defendant was kind of retaining all of these commissions on the sales he was making, and therefore kind of like.
So he was stealing.
Yeah.
Just stealing, embezzling, all the usual stuff. And there's not an oppression claim here. So there's a breach of fiduciary duty claim. And so that raises this issue of, is the harm that the defendant caused to the company, or is it distinct to the shareholder, right? For the shareholder to stand in to sue the defendant, his harm needs to be distinct from the rest of the shareholders in the company.
Right, yeah, he either has to show that the injury is separate and distinct from injury that was suffered by shareholders in general, or that it was the result of the defendant's breach of a duty owed to the plaintiff that is separate from the defendant's duty owed to the company.
So this is the principle that you grapple with when you're trying to establish a fiduciary duty. You don't have a partnership argument. You don't have a direct claim under the oppression statutes, and you have to show that there's this unique and distinct injury to the shareholder. And I think it's very difficult to do, and most of the decisions result in dismissals of the claim. And I would be curious if anybody's ever litigated this issue and had any experience with it. Dave?
Well, you and I litigated it like 12 years ago.
In the Dawson versus
we had
Delisle
everything
case.
dismissed except for the shareholder oppression.
We got smoked, didn't we?
We did, yeah.
Yep. So what was the
Deservedly so.
what was the court's holding in that case?
It was, we had a plethora of claims, and basically he dismissed all of our shareholder claims except for the oppression claim. He probably would have dismissed the oppression claim too, except for it was statutory, so he kind of had to let it go. But he basically said, it was all derivative, and we didn't make the demand, so you're gone.
Okay. All right. So and I think this highlights, and I'm going to segue into the next speaker, but it highlights the importance of the oppression claim as a direct claim, because when the legislature put together the oppression statutes, it empowered the minority shareholders with a direct claim which didn't require demands, didn't require arguments about whether there was a fiduciary duty. It didn't require us to wait 90 days to bring suit. And I think that if you read the Estes decisions, the early Estes decisions, it really highlights that these statutes were designed for privately held corporations where individuals who hold the shares are working there, are invested there. It's not the publicly held world. You don't have the defenses that come along with the corporation statutes when derivative demands are made with respect to establishing committees to review claims, and then you can move the court to dismiss it. The business judgment rule is clearly entrenched in that other world of the derivative demand, and it's seeped into these direct claims, and it's a little unclear how it plays out. But I think that looking at these cases where people are struggling to establish fiduciary duties under these various theories does highlight the policy and the purposes behind the oppression claims, which is to create this direct cause of action where we can circumvent completely the arguments about whether people are fiduciaries and what those fiduciary duties are. Even though the fiduciary duty principles of law do get imported into the analysis, those direct claims were designed by the legislature to completely cut out those arguments. So in going through these business court decisions, what struck me is where all these people are struggling to sort of get around the failure to have the oppression claim. It does highlight why the oppression claim is actually so powerful for a plaintiff.
In this case, it's actually the one we just referenced, where the plaintiff had brought the shareholder oppression claim against the CEO. And this also just kind of highlights the issue of a direct cause of action versus indirect cause of action for breach of fiduciary duty. And in this case, the court found that the plaintiff had alleged a direct cause of action where the defendants had entered into a settlement agreement that basically cut out the plaintiffs from receiving funds of the settlement, but allowed for other shareholders to receive significant disbursements. So there really was a huge disparity between how the shareholders were treated. A month later, got another case issued by the Oakland County Circuit Court, which deals with the same issue but comes to the opposite result, where the plaintiff had alleged that a merger had kind of left him with inadequate consideration. He thought that the directors had failed to maximize their value and had failed to disclose information. But in that case, the court had the fact that the harm was the same among the shareholders, it was just in proportion to their shares. So in that case, they had failed to state directly.
I have a question about that last case. Did the court raise the issue of dissenter's rights in that case? Or did anyone raise the issue of dissenter's rights? Because it seems that rather than bringing an oppression claim, the plaintiff would have been limited to a fair value under the dissenter's rights statute.
No, they didn't bring up that issue, at least in the decisions that we reviewed. So no. How would the dissenter's rights concept have played into this?
Well, if they're being cashed out through a merger, that's what the dissenter's rights statutes provide, is that if there's corporate action that essentially dispossesses you of your shares in that way, you can bring a claim under the dissenter's rights statute. They have the option to buy you out at fair value, what they believe to be fair value. If you disagree as to what fair value is, then you litigate it, and of course going to determine what the fair value is, but that is the remedy.
Would you agree that the dissenter's rights concept, though, is totally underplayed in this litigation? Like, you don't see it often, do you?
Well, you got to have specific circumstances. I mean, I think there are a lot of cases that are oppression cases where maybe a plaintiff would like to be able to bring a dissenter's rights statute or claim, but the actions that are being complained of aren't actions that rise to the level of actually dispossessing the plaintiff of their shares.
So it's a good alternative argument if you can't rise to the threshold of the oppression statutes. It's a way to trigger the bias.
It's got to be a specific type of a case. There has to be an action that's being taken, a proposed sale of the company, a merger, something like that. It can't just be, I'm being treated unfairly. There's got to be an event that's going to happen that's going to cause people to lose their shares. Do you remember the Elyse case when we were working together at Mantese Honigman? That was a dissenter's rights case. Dave Hansma was working on that case as well, actually.
Okay.
And that was one of the few that I have seen where there were oppression claims that were being brought, but there was also a clear dissenter's rights case because they were related corporations, one of which was being sold in its entirety. So that part of the case was easy. The dissenter's rights statutes are pretty clear, and the remedy is crystal clear under those statutes.
Let me ask a question on that point.
Sure.
Would that apply, not necessarily in a merger context, but in a context of forced sales of businesses where you have a shareholder that has not agreed to the sale price of the entities, but the CEO and operator has been allowed by the court to sell the entities? You see what I'm saying? So it's not exactly a merger. It's not a merger situation. It's a merger where the court has authorized the CEO to sell the entities. The minority shareholder is being forced out and forced to accept a price that they don't agree with. Do you think that might apply there?
I think that's an interesting scenario, and I'll tell you, if I represented the plaintiff, I would absolutely raise it. But if you have the imprimatur of the court on the proposed action, the proposed sale, my suspicion is that the court's not going to find that qualifies under the statute.
Okay.
But I've not seen that play out, and certainly I would raise it.
I've got one going on right now that's not something I consider bringing, but I was.
Take a look.
The statute does include dissenters' rights for sale of substantially all of the assets outside the ordinary course of business.
Well, this clearly applies in the one particular case I have in front of Judge Neff right now. Thank you, I appreciate that. I hadn't thought about that idea.
All right, well, that concludes the overview of 2019 Business Court Opinions, which we found interesting. So I hope you all found them somewhat interesting too. And we'll turn the floor over to the one and the only, Paul McCarthy.
How do I advance this thing?
Push that button right there.
So I would encourage everyone, I mean, there's a bar over here. And everyone's sitting right here. I mean, I'm going to be insulted if everyone just stays sitting. Just go get a drink, have some food. I'll be up here blathering away, but I'm going to try to do it quickly. Those of you who I don't know, my name is Paul McCarthy. I'm a commercial trial lawyer at Rhoades, McKee. Kind of a frustrated finance guy, so I find joy and humor in numbers. I should have become a CPA, but I didn't, so this is what I toil on. So I'm here to talk about shareholder employment rights, and I think this is an issue that is not very well handled either by the lawyers or by the courts. So if you think of shareholder rights as like a golf ball, right? So the golf ball underneath that exterior, at least it used to be the case, you used to have all of those different strands of rubber bands in the golf ball. So what these shareholder rights include, in most cases, a very significant employment component. And when you have a shareholder oppression case, I mean, you are in land of equity, baby. The court can do anything. You get that in divorce, and you get it in shareholder oppression cases. And those are about the only two areas I've, in my practice, have run into, just pure equity. So it is critically important for the lawyer, I think, to understand the economics of the business, to be able to effectively articulate to the court the importance of what does that employment component mean, and why is it important in the context of that company. You have to marshal the facts and have the judge understand it, because as we're going to review here, we're going to see that courts just look at, okay, shareholder rights, you get the right to vote, you get the right to be involved in a meeting, you get the right to ask for records, you have the right to receive distributions. And then it has this provision in the Act, which was amended not very long ago, to now specifically reference the ability to include employment. But it does it in a wonky way, because our legislature is doing this. And here's the language. So it may include the termination of employment or limitations on employment benefits to the extent that the actions interfere with distributions or other shareholder interests disproportionately to the affected shareholder. My invitation to you is focus in on these words, or other shareholder interests. And you're going to have to work that up, you're going to have to understand it, and you're going to have to be able to articulate it and advocate it to the judge and to the court so they understand what it is you're talking about. Because this provision is receiving short shrift in courts. Courts are looking at this in isolation. They're not looking at it as that golf ball of intertwining rights. They're looking at it as, okay, this is your employment. Your employment can be terminated. You can be broomed by the majority owner. So let's take a look at one of the cases. This is a case from Judge Yates' court, which I have no criticism of what Judge Yates did, but I do have some comments about what the Court of Appeals did in Pitch. So, as is common, in this oppression case, they were talking about, as a component of it, employment. And the Court of Appeals had this analysis on the employment aspect. Plaintiff's termination from employment with the corporation does not necessarily constitute shareholder oppression. It might be evidence of oppression if it violates the shareholder agreement, but it does not. Okay, let's stop there. Footnote. Okay, does it violate the shareholder agreement? If it does, that's a really great opportunity, but pound on that. It violates the shareholder agreement. It's evidence of oppression. Bang, we hit it. But if it doesn't violate the shareholder agreement, that doesn't by default mean that it isn't oppression, because we've now been armed with the Franks decision, which underscores the importance as advocates for us to be able to articulate and drive home motive. So what's motivating the change?
Forgive me, if it would be part of the shareholder agreement, are you saying it would be a specific clause granting employment?
Might.
Might, okay. So that
It's
might
probably
be
more going to be sloppy language. It's kind of, doesn't really say anything about securing employment rights, but it's talking about employment rights, and it's not referencing terminating.
But absent that, what else would you have that would guarantee employment other than an implied statement?
I've never run across a guarantee of employment, but you're going to look at the shareholder agreement, you're going to look at the operating agreement, you're going to look to see how well is that anchored in. Typically not very well, but the reality is, so let's stop for a second, let's put the shareholder agreement on the desk, and let's step back and look at reality. Reality is privately held business. A very significant driver of value is in employment. That's the reality. And you need to be able to just hammer that to the judge so that the court understands what that component is. So here in Pitch, they say, well, it doesn't violate the shareholder agreement. And so they go on to say, well, then it's not. Well, they go on to say this. Termination of their employment was an action plaintiffs suffered as employees, not as shareholders. And it did not violate the shareholder agreement. Therefore, it is not evidence of shareholder oppression. No, that's just bad. We need to do better. We need to be able to argue to the court and marshal all of the economics of that situation. So then the court does this. And this is just, I'll let you decide. Plaintiffs claim that they receive no income from a profitable company in which they have a 40% combined ownership interest is not entirely true. Now listen to this. To the extent they are referring to receiving no bonuses or distributions of any kind, the record evidence clearly shows that these are perquisites reserved for employees, and employees ceased to be employees in 2006. Furthermore, it says this: record testimony established that the company has never paid dividends and has always tied distributions, i.e. profits, to employment, and has never paid shareholders and directors simply for being shareholders or directors. What? Distributions are profits. You don't pay distributions for employment. You pay bonuses for employment. Distributions are profit. I mean, this is just a complete, I don't know what happened where that ends up on the printed page, but someone's going to cite that against you in a court. I mean, we're all going to have to be able to articulate our way around that, but that's just, here's what that is. When I had here. And was about time. We're going to skip important to know. We'll skip that. So let's talk about shareholder benefits. And as advocates, we need to be able to understand this really well. So you have cash flows through employment. You have distribution of profits. You have the appreciation in the value of the stock. You have your statutory shareholder rights. You have your rights that you've secured by agreement, shareholder agreement, operating agreement, etc., articles, bylaws, and then you have the ultimate liquidity event. And so, as important as any other issue in that is you hold the stock, the shareholder owns the stock, that shareholder has the inherent right to determine when they let go. And sometimes in shareholder oppression cases, that's what happens. It gets pulled out or it gets reduced in value. But let's just focus on the employment aspects of that. So let's talk about the employment cash flow. So we have typical employment components. You have base compensation, you have bonus compensation, you have health insurance. But let's caveat that in privately held companies, you often have very rich executive compensation plans, completely unlike what we have for health care. Very rich. You have life insurance. Caveat, privately held companies oftentimes have extraordinarily rich life insurance plans, unlike anything anyone in this room has. It is of enormous value. Vision, dental, 401k match, CERP, that kind of stuff. But then beyond that, you have employment often includes auto, lease, or company, the auto insurance, fuel, maintenance, oftentimes or sometimes the fleet of vehicles to family, to various people, your kids. Sometimes you'll have unique lease arrangements where the company is paying an extraordinarily high lease arrangement. But because they can do that, they can expense it, reduce their income, and then in like 2 years, someone is walking off with a $75,000 car. If you don't understand that issue, you're not going to be able to articulate to the judge or to the court why the termination of employment, motivated by some sort of grumble or fight or request for records or other assertion of shareholder rights, is an important issue. Cell phone, that kind of stuff. Here's an area I love to get involved in, the discretionary expense area. In cases I handle, I try to quickly determine, is this a clean company or is it a dirty company? Is it a sophisticated company or is it Slopville? Because if it's Slopville and it's dirty, it's a field, it's a playground for mischief, for people to just expense all sort of bullshit through the company, and it's for the benefit of the owners. And so let's back up for a second and go to a truism in privately held companies, because I sometimes don't think courts understand it. Our court understands it, and probably most business courts understand it. Privately held companies are not designed to maximize net income. Don't care. Maximize cash flow to the owners. So as lawyers and as advocates, we need to be able to understand where that cash flow is coming from. We need to be able to quantify it. And so a lot of this is coming through that employment chain because they've got the corporate credit card. They're charging all of their meals. They're flying all over Hell's Half Acre. They're staying at $500 a night hotel rooms. I just handled a situation where there were two 50-50 owners, which, why do people still do that? But they do. And they have to try to figure it out all the time. Between two of them and their spouses, they had like 7 or 8 corporate credit cards, and on a yearly basis, they were running like $190,000 through the company. And I had to end up in a fight with their CFO about how it was that I figured out the average. Just one guy, one of the two, who had a very good appetite for fine food. He had 2.2, on average, 2.2 meals per day charged on this thing. And he's like, that's all business expense. Gotta eat. Gotta eat, want to be productive. So I've got to eat. I'm working through my project. I'm like, are you kidding me? This is absurd. But anyway, all of these are the various different strands of value that go with employment and go into privately held companies. Sometimes you end up in situations where companies are paying all sorts of crap. You can see it in the general ledger. You look at the corporate credit cards. You're like, wow. Wow, that is, I mean, I've got them now. This is ridiculous. But you might not have them. I mean, you got to go back and you got to look at the accounting treatment. Because even though the company's paying a bunch of garbage out, that doesn't make it wrong. What makes it wrong is the accounting treatment. So if they're aggregating it into a shareholder receivable and offsetting it against the distributions account at year end, that's fine. If they're aggregating it in some way and then offsetting it against or booking it to the W-2 income at year end, that's fine. Those sorts of things. Two other things and I'll shut up. The form of the company also drives conflict. So if we have a C Corp, C Corps, they don't want to have dividends, okay, we don't want to do that. Maybe they're more tempted to do that now with the tax law changes, but I've not seen that just yet. So C Corps, it's all going to go in comp. All the value is going to go out in compensation. They're going to avoid double taxation. But then you get into S Corps, and it's the opposite is true. They want low comp. They're going to try to get away with unreasonably low compensation, and then it's going to just be an absolute, you know, a festival of all of the other value that's going out to the shareholders, whether it's by way of distributions or otherwise. So the other thing on my last comment on Kahn is to be able to articulate to the court what was the status quo whenever we had one. What did that look like? And then evaluate what's changed. Because oftentimes someone gets broomed, the people who are remaining, they jacked up their pay, and then you have to evaluate all of those benefits in addition to their comp, and then you can make the argument or determine if you take comp, bonus, all the other slush that's going through, add it all up, aggregate it, because your business valuation people are going to do just that, and then compare that amount with what market-based compensation is. Because as that amount exceeds market-based compensation, they're screwing the other person. To say nothing of all of the employment benefits that they've taken that they've taken from them because they're pissed off, they're mad, they're going to use their majority control. The myriad reasons that occur that create shareholder conflict. And now I'm super insulted. No one got up and got a drink. What is the matter with you?
Oh, right here.
Thanks, Donald. That's all I have unless anyone has any questions.
So, in a case that you have a minority shareholder or a member, and you have a separate employment agreement with the company, and the employment is at will, how is that enforceable? Can you just terminate the minority based on the employment agreement even though they're a shareholder or member?
So the question is, if you have this is an owner situation, you have a shareholder agreement or an operating agreement, and then you have a separate employment agreement, which says you're at will, we can fire you because we don't like the color of your tie. That would from a 30,000-foot view be something in favor of the company or the majority owner, but I don't think that is necessarily dispositive. Again, you've got to look at the motivation, because if they were motivated to fire them because that member, that shareholder, you know, asked to receive the corporate records or asserted some other shareholder right, and you can connect the dots to that, I think the court ought to step up and block that. To me, it's all motivation. If it's just like, hey, this guy's, you know, and in the pitch cases, Judge Yates has told me before, like these people were fighting. I mean, they couldn't, I mean, there was justifiable reason why that termination needed to occur. But if it's motivated by something that is really retaliatory or designed to harm, I still think that gets before the judge.
Or if, you know, the employee fails to show up for work, fails to perform work,
Right.
which would normally be done. Well, those are examples of you can terminate.
Right.
And then they would keep the interest in the company as a member or shareholder, but not as employee.
Correct.
Sorry to keep asking questions. Obviously, I see the case where the shareholder terminates. What about in this situation, just like I asked in the mergers to acquisition, where the court stepped in and forced the dissolution and sale of the company? This one particular case, the CEO and shareholder was the CEO for 14, 15 years. It's a divorce case between husband and wife who own all the assets. Judge removed the acting CEO, put the wife in.
I'm sorry, hang on a second. Is this like a double divorce? Are we talking about
Yeah, it's
50-50 orders and a divorce?
it's a double divorce. It's a divorce and a business divorce.
That's like hell of a...
Yeah, I'm gonna be at this case for the next 10 years. In the situation, the shareholders, 50-50, the one shareholder is 50%. Husband ran the company for years. The company was profitable the entire time he was running it. Judge, for unknown reasons on the record, terminated his employment as the CEO, kicked him out, and appointed the wife. So they terminated his employment there, and the wife in 1 year has devalued the company by 25%. How do you think that plays in the employment context? Because now you get the judge terminating his employee, not a shareholder, a majority shareholder, and a board member or something.
The family court did that?
Family court terminated.
Don't release any claims in your divorce judgment.
Okay. We haven't.
And then sue.
We've got that
or file
case
a separate
going
lawsuit for
on. We've got a
oppression.
business case going on in federal courts. So we're arguing in 2 courts. It's gotten really ugly really fast. I'm just curious, in your opinion, how to.
I think we'll have to talk about that sidebar.
Fair enough. Fair enough.
That
Thank
makes
you.
my head hurt.
Yeah, mine too.
You mentioned at the outset that it's equitable or fair that you're looking at. If you build into a shareholder agreement or operating agreement that you can be penalized under certain circumstances, like a 10% discount on your membership interest, would that be disregarded by a court?
I don't think so. I mean, we're in Michigan. It's freedom to contract, baby. I mean, CLAP says it means what it says, and that can be put in a collision force with motive, however. But if the agreement, for your point, it's someone's going to be, if there's a liquidity right and there's a discount, it means what it says.
I would chime in on that though, Paul. One of the specifically enumerated remedies under the shareholder action statute is that the court can strike or change provisions of the bylaws or shareholder agreements. I will say in 15 years of practicing in the area, I have never once seen a judge do it. But in theory, they have all kinds of power.
Or to Mark Rossman's point, I had a case where the agreements were crystal clear, but then the argument was this overarching partnership. Wait, hang on, we have agreement. No, they're all subordinate to this overarching invisible barrier of partnership fiduciary responsibility. All right, I'm going to stop talking and I'm going to go to the bar and get something to drink.
All right. Come on, man. All right, next up is Ian Williamson. He's going to enlighten us on the nuances and the ins and outs of the BJR.
Actually, I'm probably going to confuse everyone even further.
Good. Then we'll ensure a 3rd annual symposium.
Great. My name's Ian Williamson. I'm with firm Mantese, Hansma, McKee out of Detroit. I've been working in this field basically my entire career. I was my first year of law school was when Estes 1 was issued. I graduated from law school and was taking the bar exam when Franchino versus Franchino was issued. I started working doing shareholder litigation that fall. It's been very interesting to see the changes in the field. We worked for a long time with, as many of you know, we worked for a long time with very little published authority in this area. I'm talking about the business judgment rule today because of a conversation I had about 6 months ago with another attorney talking about the direct derivative distinction and whether the legislature actually intended to give shareholders in a closely held corporation an end run around the derivative statute requirements. I made a forceful argument that that was in fact the case, and at the end of that conversation, the other attorney, who actually is Dan Quick, who will be presenting at the Detroit version of this symposium, asked me, well, if that's the case, do you think the business judgment rule still applies in the context of repression cases? And I had to think about that for a minute. I said, you know, I don't want to answer that right now. Give me some time to digest that. So now I've been digesting it for the past 6 months, and I figured I might as well talk about it tonight. So I'm going to basically give a quick refresher on the business judgment rule, talk about how it compares with the language of the shareholder oppression statute, how courts have applied the business judgment rule in oppression contexts in Michigan, and how the Court of Appeals approach to the business judgment rule argument in Frank's case is likely to impact oppression cases going forward. All right, let me put myself to my slides here. Quick refresher on the business judgment rule. We're basically talking about a principle of judicial deference. This is a principle where we're saying because judges are not corporate directors, and because judges aren't going to be sitting in the boardroom and having continuing jurisdiction over what's going on with these companies, judges should not be making the decisions to run the company. And the judges should not be second-guessing the decisions that the directors are making, who are there, in theory, day after day, developing the corporation's policies. As stated in the Delaware law, in the case that probably a lot of us studied in law school, Aronson versus Lewis, the business judgment rule is a presumption that in making a business decision, the directors of a corporation acted on an informed basis, in good faith, and in the honest belief that the action taken was in the best interest of the company. Now, this principle was relied on by courts to avoid second-guessing directors, and absent an abuse of discretion by the directors, courts generally assume that this judgment is going to be, that the business judgment of the directors is going to be respected. Because the board is presumed to have acted properly, the burden is on the party challenging the decision to establish facts rebutting the presumption. Now, this is a good succinct description in Aronson, but I will point out that myself to my slides here. Quick refresher on the business judgment rule. We're basically talking about a principle of judicial deference. This is a principle where we're saying because judges are not corporate directors, and because judges aren't going to be sitting in the boardroom and having continuing jurisdiction over what's going on with these companies, judges should not be making the decisions to run the company. And the judges should not be second-guessing the decisions that the directors are making, who are there, in theory, day after day, developing the corporation's policies. As stated in the Delaware law, in the case that probably a lot of us studied in law school, Aronson versus Lewis, the business judgment rule is a presumption that in making a business decision, the directors of a corporation acted on an informed basis, in good faith, and in the honest belief that the action taken was in the best interest of the company. Now, this principle is relied on by courts to avoid second-guessing directors, and absent an abuse of discretion by the directors, courts generally assume that this judgment is going to be, that the business judgment of the directors is going to be respected. Because the board is presumed to have acted properly, the burden is on the party challenging the decision to establish facts rebutting the presumption. Now, this is a good succinct description in Aronson, but I will point out that the business judgment rule is applied in slightly different ways pretty much all over the country. This is the basic principle of it, but the parameters of it are a little bit fluid depending on where you're at. But in general, the business judgment rule is requiring that courts assume that the directors have acted properly, unless the plaintiff can establish facts showing otherwise. So there are really two aspects to the business judgment rule. We've got a substantive aspect and a procedural aspect. The substantive aspect is that the directors are presumed to have acted in good faith, unless the plaintiff can provide evidence at the outset that suggests that the directors acted with bad faith, fraud, or consciously against the corporation's interests. So in other words, a negative outcome by itself of directorial actions is not going to be sufficient to establish liability without something more. There's got to be something besides just the negative outcome. The procedural aspect of the rule has two sides to it. On the one side, a court can dismiss at the outset an action based on the business judgment rule that there aren't specific facts pled that will convince a court that the business judgment rule should not apply. Basically, if you don't plead the exceptions or the carve-outs, things like breaches of the fiduciary duty of loyalty, bad faith, things along those lines. if a plaintiff is able to supply evidence establishing that the directors breached their fiduciary duties of loyalty, acted in bad faith, acted in a self-interested way, that's when the burden shifts to the directors. And at that point, the directors have to establish that their actions were, for a transaction, for example, that they were entirely fair, that the price was fair, that the way that the transaction was entered into was fair, fair dealing, fair process, fair price. Here, evidence of a negative outcome plus something like self-dealing shifts the burden over to the directors. And at that point, they have to produce evidence of fairness in order to avoid liability. So the implications for this is that drafting a complaint are, one, you gotta be specific. If you don't plead the specific facts to fit yourself into that exception or carve out, you're giving the defendants a chance to file an early motion to dismiss and kick the case. Another implication is when you were at the initial disclosure and early discovery stage, which we're all going to be doing in state court very soon now, in addition to in federal court, show the evidence right away. If you've got evidence that shows or suggests bad faith, or that suggests self-dealing, breach of the fiduciary duty of loyalty, don't hold it back, because if you hold it back, then the business judgment rule might come into play. So this has been codified in case law and also in statutes in Michigan, at least. As far back as Dodge versus Ford Motor Company back in 1919, the Michigan Supreme Court was acknowledging the business judgment rule, acknowledging that it applies and protects corporate directors, and acknowledging that courts will not substitute their own judgment for that of corporate directors and officers in the absence of fraud, or breach of trust, bad faith, neglect of duty, willful abuse of discretionary powers, or perversion of the corporate purpose. We also have codified in statute MCL 450-1541A, which states that directors will discharge their duties in good faith with the fear of an ordinarily normal person and in a manner reasonably believed to be in the best interest of the corporation. This statute basically lays out the expectations of directors and officers in a way that is consistent with the presumptions that the business judgment rule provides. So the type of evidence that would avoid the presumptions of the business judgment rule are typically also going to establish a violation of the statutory standard of care. So let's think about this in the context of our shareholder action statute, MCL 450-1489. What our statute says is that a shareholder may bring an action in the circuit court of the county in which the principal place of business or registered office of the corporation is located to establish that the acts of the directors or those in control of the corporation are illegal, fraudulent, or willfully unfair and oppressive to the corporation or to the shareholder. Now, some would argue that the statutory language that we have is not consistent with the business judgment rule. For example, under the business judgment rule, the court cannot consider or second-guess actions taken by the directors in good faith, despite the consequences. And the presumption is that the actions that the directors have taken are in good faith. The statute says that shareholders can bring an action to establish that the acts of the directors are, among other things, willfully unfair and oppressive. That's not really consistent with the presumption of good faith. And the business judgment rule carve-outs don't perfectly match with our statutory language. For example, if you're alleging in an oppression claim that the directors have done something that is fraudulent, well, that fits right into a business judgment rule carve-out. If it's fraudulent, usually we all agree the business judgment rule is not going to apply. But when you get into willfully unfair and oppressive, it's a little bit more of a gray area. This is where the business judgment rule could theoretically apply if the allegations in a complaint don't really fit into a business judgment rule carve-out. Now, common fact patterns that we see in oppression claims are things like, we see things like interested transactions, self-dealing, improperly funneling corporate funds to other entities, things like that. These are fact patterns that will probably preclude the application of the business judgment rule on their face. Self-dealing is a breach of the fiduciary duty of loyalty. There's plenty of case law out there that says if you breach the fiduciary duty of loyalty, you're not entitled to the business judgment rule protection. But other oppressive fact patterns that are common oppressive fact patterns may not involve outright illegal or fraudulent conduct. Things like squeeze-out and freeze-out tactics, withholding dividends, probably one of the primary ways that we see people engaging in oppressive conduct, terminating or not offering employment to a shareholder, removing someone from the board of directors, denying access to corporate information. These often culminate in things like a buyout offer below fair market value, maybe less frequently a cash-out merger or something along those lines. But these tactics don't really fit into an exception to the business judgment rule. And these tactics are typically justified by defendants as being consistent with, or at least not adverse to, the corporation's best interests. So because of that, in my experience, it's very common to see the business judgment rule raised as a defense in oppression cases, particularly in dividend starvation cases. In these situations, the business judgment rule, as is described in the common law, theoretically can prevent a court from second-guessing directors' actions and preclude any judicial interference. And that's exactly what defendants typically argue should happen in these cases, that the court shouldn't even really consider what the directors have done without some proof that they did it in bad faith, without some proof that the dividends were shut off because they wanted to harm that particular shareholder. Defendants will argue the business judgment rule means that you can't even dig into what the directors have done. Now, the way that courts in Michigan and in other areas have applied the business judgment rule shows a little bit of confusion as to how much protection it should really provide to directors in oppressive situations. We have, for years, seen commentators arguing that in the closed corporation context, the business judgment rule really should have a diminished place or maybe even no place at all. O'Neill and Thompson, for example, they've been doing their treatise on oppression minority shareholders and LLC members for decades. They have an entire chapter devoted to this in their current treatise called The Need for Judicial Discrimination in Applying the Business Judgment Rule in Oppression Contexts. You've got law professors like Professor Ralph Peoples saying that an obvious potential for self-dealing exists when the same group establishes its own salaries and decides on dividend payments for shareholders who aren't employees. That's in the use and misuse of business judgment rule in a closed corporation in the Notre Dame Law Review in 1985. So for a long time now, we've had people saying, this is really a publicly traded company doctrine. Maybe we shouldn't really be applying it in a closely held company doctrine, or at the very least applying it in a limited fashion. The courts aren't necessarily saying the same thing. Dodge versus Ford Motor Company, the business judgment rule was raised as a defense in that case, and there were two issues that were being examined by the court. One was whether the directors should have authorized the dividend. The other was whether the directors were able to embark on an expansive growth plan for the company that would take it well outside of auto manufacturing. In Dodge versus Ford Motor Company, the court said, we're not going to apply the business judgment rule on the dividend issues. You've got $60 million in cash. This is 1919. You're bringing in another $30 million in cash every year. Be reasonable. You got to issue a dividend. But even though the directors of the Ford Motor Company were talking about using millions of dollars, tens of millions of dollars to buy a iron ore mine up in the Upper Peninsula, build a dock, build an iron ore foundry, and do many other things well outside of auto manufacture, the court applied the business judgment rule and said we're not going to second guess those decisions. It's within their purview as directors. We're not going to second guess their judgment. Another Michigan case where this has happened is Miller versus Magline, which before the oppression statute was one of the key pieces of jurisprudence on what shareholders could do in cases where they were being oppressed. In that case, the shareholders again were looking at a lack of dividends and an increase in compensation of the directors of the company. In Miller versus Magline, the court acknowledged the business judgment rule's existence, just like they did in Dodge versus Ford Motor Company. But at the same time, they said, you still got to pay a dividend. The defendant's directors' positions made it impossible for them to give an impartial answer to the determination as to whether dividends should be granted. But they did it halfway, just like in Dodge. They declined to second guess the director's business judgment in setting bonuses, even though the trial court found that the bonuses were substantial and that management was acting in a concerted fashion because the individual director said, I'm going to recuse myself from voting on my own bonus. I'm going to vote Joe a bonus of $6 million, but I'm going to recuse myself from Joe voting on my bonus of $6 million. You should respect our business judgment. And the court did. So federal courts in Michigan have kind of taken a similar approach to this, where you see the business judgment rule used a little haphazardly. And Wogan versus Clark, which is a much more recent case from 2014, the court applied the business judgment rule in its analysis, rejecting the plaintiff's suppression claim based on dividend reduction. The court said, okay, the dividends have been reduced. You as the plaintiff are getting less dividends, but you haven't shown me that it was a product of fraud or a product of bad faith. So the business judgment rule applies, and there's no shareholder oppression claim. Just a year later, in Blankenship versus Superior Controls, another federal court, the Eastern District this time, came to a different conclusion. That was another dividend starvation case, and the court in Blankenship acknowledged the business judgment rule, but did not apply it to the dividend portion of the case. The court said that the reasons offered by the defendants to support their actions of cutting off the dividends were not sufficient to have the court apply the business judgment rule to grant summary judgment on the plaintiff's suppression and breach of fiduciary duty claims. So 1 year, dividend starvation is something protected by business judgment. A year later, you've got to go above and beyond to apply the business judgment rule to dividend starvation. Now, there are some other key differences in these cases. There was a larger surplus in profits in the Blankenship case, but the way the court articulated the reasoning and the way the court applied the business judgment rule was pretty different. Now, what we're seeing in Michigan now, though, with Frank's case, is a movement in the direction of, I think, a lot more clarity. This is a case that's been pending for close to 7 years now. A lot of people in this room have their fingerprints on it. Mark Rossman and Brian Saxe were involved in briefing this case early on. David Hansma has done some work on this. This is going to trial for the second time in March of 2020 after coming down on appeal. And there was a business judgment rule argument raised in this case whereby the defendant said, Judge, because of the business judgment rule, you cannot look at any of the actions that we took that are now being alleged as having been oppressive actions, because every single one of these actions, for you to look at them in an oppression context, you would be second-guessing our discretion as directors, and we have protection under the business judgment rule. And it was an aggressive business judgment rule argument, and that aggressive argument, I think, has yielded some clearer direction on how this applies in shareholder oppression cases. The Court of Appeals addressed the tension between the business judgment rule and the statutory language by holding that a shareholder necessarily overcomes the business judgment rule by presenting evidence to establish the elements of a claim under the shareholder oppression statute, because that statute identifies wrongful conduct and provides a remedy for it. So in essence, the court is holding that a properly supported oppression claim necessarily fits into the business judgment rule carve-outs. Even actions that are generally subject to business judgment rule protection when viewed in isolation are not subject to business judgment rule protection in the oppression context because they will be evaluated in light of the totality of the evidence. They're going to be viewed along with every other action that's been taken, and the court's going to look at them all together instead of saying, because of the business judgment rule, I'm not going to dig into any of these decisions because I don't have evidence that this specific decision was the product of fraud or the product of bad faith. So the Franks holding helps to clarify that the court can't simply look at actions in isolation to determine whether they are or are not subject to judicial review. They're all going to be subject to judicial review because of the nature of the oppression claim. It's an equitable claim, it's a big picture claim. We've got cases like Matagula a couple years ago saying that the court's going to look at everything when you're deciding whether oppression exists. And what this means, I think, is it's going to be a little more difficult for defendants going forward to convince a judge that the business judgment rule precludes any second guessing of director's actions. Franks provides some context for how and why the business judgment rule doesn't really operate as a gatekeeper to prevent judicial scrutiny in oppression cases, but it doesn't really fully close the door on the business judgment rule's application. I think we're still going to see it in oppression cases, but I think it's going to be a smaller part of the defense going forward. And that's That's a lot of information I've just thrown at you, so if anyone has any questions, I'm happy to answer them. If not, I'll turn this over to David Hansma, who's going to go a little bit more in depth in Frank's case.
I am David Hansma. I have worked with Ian and Mark and Brian. I don't know why Mark thinks I'm going to give a particularly defense-oriented analysis. I think I'm going to give a correct analysis. Yes, I'm going to talk about Frank versus Franks. We're running a little bit behind, so I'm going to breeze through some of it pretty quickly, and other parts of it spend a little more time on. In Franks, there's really two problems at issue. Number one is that the company had a long history of paying pretty good, substantial dividend, and then it just stopped. And then about 5 years later, the defendants started making offers to the plaintiffs to redeem their equity for a really low price. And they had done a valuation, and they knew that the price they were offering was way below what the value of the stock actually was. So the plaintiffs obviously brought an impression claim, and their theory was that it was a squeeze out. And you can see how that could be a squeeze play, because the plaintiffs are non-voting shareholders, they're not involved, they can't change anything, they're now not getting any money for their shares, they haven't in years, and now they're presented with this scenario where, well, if I want to get out, if I want to get anything for my stock, I might as well take what they're offering, and that's sort of a classic squeeze out shareholder oppression play that we see.
On that point, what obligations does a majority controlling faction have to a minority in the context of a negotiation for the buyout of shares? And are they allowed to lowball the minority shareholding interest? Or did the decision suggest that that could be a problem, or that they're allowed to negotiate at arm's length even though there's this fiduciary relationship?
Well, I think that what the decision suggested is it sort of depends on the facts of the case. What the defendants argued is sort of two pieces. Number one, decision not to pay dividends. They just argued that's a classic business judgment decision, so no liability there. Second is that the offer to purchase shares, they said, was just part of the negotiating. I don't know if they used the word tactic, but it was a bargaining process. And they presented evidence that, after the plaintiffs pushed back, they raised their offers several times, and they argued, this is just part of the process. It wasn't an effort to squeeze anyone out. And what we ended up seeing is parties filed cross motions for summary disposition. Trial court held four things that we're kind of concerned with. Number one, granted summary disposition to plaintiffs. So it's determined as a matter of law, this process was willfully unfair and oppressive. Second, determined as a matter of law that the proper remedy is a buyout. Didn't have an evidentiary hearing before that. Determined that at summary disposition. Third, then held an evidentiary hearing and adopted plaintiff's valuation. And in that process, the court held that it could not apply discounts for lack of control and lack of marketability.
Did it hold that it couldn't under the law or in its discretion
That it could
apply
not.
the discounts?
If you look, I don't know, if you look at what the court said, it says right in it, the trial court stated unequivocally or clearly, I forget exactly, that it could not apply discounts. It didn't.
That is wrong under the law.
That is wrong. What the Court of Appeals held is that they do have discretion in appropriate circumstances to apply discounts. So we have sort of three things going on in the Court of Appeals that I'm going to talk about. Number one is the court held that there's now a specific intent element in an oppression claim. You see here, the plaintiff has to show not just the significant action that interfered with the interests of the shareholder, but they did it with the intent to substantially interfere with the interests of the shareholder.
Does that change anything under the statute, do you think?
It does.
Or does it just interpret the statute correctly?
It interprets the statute incorrectly, as we will get to. Second, as Ian mentioned, the court held that the business judgment rule did not bar plaintiff's claims, and we'll get to that in a little more detail. And third, on the remedy, said that court should not have determined that a buyout was the appropriate remedy at the summary disposition stage. That it needed an evidentiary hearing to determine that. and second on the remedy is that the court is neither required nor forbidden from applying discounts for lack of marketability and lack of control. Instead, the trial court should fashion a remedy that is appropriate under the circumstances. So what I'd like to do is give a little commentary on sort of these three holdings from the Court of Appeals. And I'd like to kind of start in reverse order with the remedy piece. We won't spend a lot of time on this. I just will note the Court of Appeals did not say that an evidentiary hearing is always necessary to determine the appropriate remedy in an oppression case. I think most of the time it probably will be necessary. The court noted some issues in the case, for example, that there's countervailing facts that implicates, the potential that maybe alternate relief was appropriate, that we didn't need the drastic remedy of a buyout. Also noted that there was facts indicating that a buyout could affect third parties who are not in front of the court, and therefore that given this conflicting evidence, the court could not decide as a matter of law what remedy best fit the equities of the case. I think that's frankly the correct holding. I don't view that as being controversial. Yes?
In terms of the buyout remedy, early on in the case, you get your experts, you do evaluations. You're going to have to do that now early on with the new rules. When you're actually trying the case or having an evidentiary hearing, you do valuations at the time of the alleged oppression, valuation at the time of trial, or if you get a judgment. That could be three different valuations at three different times, and I've had that and I wasn't sure what to do.
Well, I will tell you that I don't think the Franks case answers that, apart from emphasizing that the decision comes down to what is appropriate under the circumstances.
So it's anything.
So I think you're going to have to make an equitable argument for whichever one gets your client the highest valuation. Why is it equitable that we do it as of that date instead of some other date? And the defendant is going to, of course, come with their countervailing argument as to why it's inequitable that you would do that. I don't think you could lay down a hard and fast rule on that. Really, for the same reason you can't lay down a hard and fast rule on whether or not there's going to be discounts, because as the court noted in Franks, trial court has broad authority to fashion a remedy that is appropriate under the circumstances. That's the language from the statute. And again, I don't view this holding as being particularly controversial. I think that's probably correct, because it has an equitable statute. It's got a list of non-exhaustive remedies. It specifically says that they're non-exhaustive. It says appropriate under the circumstances. I think in that scenario, you can't say that there's a hard and fast rule that yes, you always apply discounts, or no, you may never apply discounts. It's going to depend on what the equities of the case are, Paul.
So in further comment to Terry's question, with the new changes to the court rules, especially in an oppression case, I think you can, in an appropriate case, make the pitch to the judge. Because it's equity, if there's oppression, whatever the remedy is, it's a court-decided remedy. And for the parties to come in and waste tens or $50,000 each on valuations before the court's made a determination of is there any oppression here to even fix, I think you can make a pitch to the judge to kind of bifurcate things and focus in on like what's really at issue here, and then figure out how to remedy it.
Yes, you could, though I've had the scenario where someone tried to do that to me, and we actually resisted that because our feeling was that the expert analysis actually was helpful on the liability stage to show sort of the oppressive nature of what was going on. And we were fearful that if you just push that till after we decided that there is oppression, we sort of lose that opportunity for the expert to highlight, why is X, Y, and Z decision that the defendant made is oppressive. So I think that kind of cuts both ways. Business judgment rule we're going to get to in a second, but as Ian noted, actually, I'm sorry, I got mixed up. So, has business judgment rule been eliminated for oppression cases? I've actually seen some people say, oh, Frank says business judgment rule doesn't apply. They look at things like this where it says the shareholder necessarily overcomes. So they say, oh, no more business judgment rule in oppression cases. And I think Ian's analysis is basically correct. That's not entirely true. The business judgment rule still has some application. I think Frank's actually, to some extent, strengthens the business judgment rule, or at least confirms that there is a business judgment application to oppression cases. And we can kind of look at some things that go on with the business judgment rule. The first thing is to remember, as Ian said, it's only a presumption, right? There's a presumption that the defendant, the directors, acted in good faith and with the care of a reasonably prudent person and in a manner they reasonably believe to be in the best interest of the corporation. But the presumption can be rebutted. As the Franks case noted, if the defendants are guilty of willful abuse of their discretionary powers or act in bad faith, it's probably going to rebut the business judgment presumption. Also, this wasn't part of Franks, but we all know plaintiff must plead in avoidance of the business judgment rule. So then we get to what Franks actually said. It said plaintiff alleged and presented evidence that defendant's decision were not taken for legitimate business reasons, but instead were taken to defraud or oppress plaintiff's interest as a shareholder. So the way I read Franks, all this is a straightforward analysis of business judgment. They're saying plaintiffs have alleged, they pled facts in avoidance of the business judgment rule. Then they presented evidence to support those facts. So they have presented evidence that rebuts the business judgment rule. If their evidence is to be believed, then it can't be a business judgment because something cannot be willfully unfair and oppressive and a good faith business judgment at the same time. It's either one or the other. But that doesn't mean that plaintiffs automatically win, because the court found that there was a question of fact whether or not defendants' actions were taken for legitimate business reasons. So the defendants still get to come forward with their evidence and say, no, plaintiffs are wrong, this was a business judgment. And if it is a business judgment, then plaintiffs don't win. It's not enough for plaintiff to simply come in and show an oppressive effect. So to say defendants took whatever corporate action and that has harmed my interest as a shareholder, it substantially interfered with my interest as a shareholder, and therefore I win. Plaintiff has to come in and show that extra showing that it harmed me as a shareholder and it did not arise from a good faith business judgment. If they do that, they have therefore rebutted the business judgment presumption. So as Ian pointed out, if you have a properly pled and a properly supported shareholder oppression claim, that is necessarily going to rebut the business judgment presumption. But if you don't have that, then you're going to lose. And it's not enough to just come in and say, oppressive effect, give me a remedy. Now, where I think the Franks case went off the rails a little bit is on the proof of intent. I'm going to skip that slide and get to what I view as being not the best analysis from the court. Because we have a definition in the statute of subsection 3, willfully unfair and oppressive conduct is defined. Read that definition. On its face, it does not require any particular intent. And this is where I think the Court of Appeals analysis is a little iffy, because they started doing this exegesis of the statute and they said, well, the liability section is in subsection 1, and that refers to acts that are willfully unfair and oppressive. And then you go to the definition, and that refers to willfully unfair and oppressive conduct. And they tried to distinguish between acts and conduct. And I think we can agree that that's poor draftsmanship, that the legislature has a section 1 that refers to acts, and then they have a definition that refers to conduct, but the word conduct never appears in the liability section. Having said that, I don't think most of us, when we read the statute, read those as being different. I don't think we read them as having any sort of different. I have always read them as being the same. And I think actually that's how the Supreme Court has read them. If you look at Frank versus Linkner, which is just 2 years ago, cause of action when the manager's actions constitute willfully unfair and oppressive conduct. So right there you have the Supreme Court in a published binding decision combining actions and conduct and treating them as the same. So it's not entirely clear to me why the Court of Appeals is treating them differently. Madagula versus Pop, I will just note that it cited the predecessor statute to the oppression case, which was the old dissolution statute, which has that exact same language, illegal, fraudulent, willfully unfair, and oppressive conduct. If you look at the case law under that statute, no particular intent requirement. But what I think the Court of Appeals was worried about, they were worried about creating a strict liability statute where someone could come in and create liability for actions that were taken for legitimate business reasons. So if you consider the issue of dividends that Ian mentioned, right, under the statute, just a strict application of the statutory language, the Franks plaintiffs could have said, hey, I haven't gotten a dividend in 5 or 6 years. That substantially interferes with my interest as a shareholder. Give me a remedy. But the problem is you also have 100 years of decisions saying that the decision whether to declare a dividend is a business judgment. And we don't grant remedies unless you can show fraud and abuse of discretion and things like that. So I think the Court of Appeals was worried about creating this strict liability scenario which would go around this 100 years of common law. I just think they did it the wrong way because you don't need an intent scenario. You can just go through the business judgment rule analysis that we just talked about. If the plaintiff is able to come in and show not just the oppressive effect, but that it arose from conduct that rebuts the business judgment presumption, then they can go forward with their claim. It's not a strict liability claim. If they can't, the case is dismissed. And I think there's a statutory textual basis for saying that because you only get a remedy if you interfere with the interests of a shareholder as a shareholder. I think in the United States, your interest as a shareholder necessarily incorporates the business judgment rule because that has been the rule in every state going back 100 years. And that, as Ian mentioned in his presentation, that's exactly what the Wolding versus Park case held a couple years ago. You had a dividend issue. The court said, yep, dividends are a shareholder right, but then the court immediately did a business judgment analysis. They didn't seem to have any problem with it. I frankly think that analysis is probably correct. And you might be saying, well, how is a business judgment analysis different from an intent requirement? And I would just mention that rebutting the business judgment rule doesn't always require specific intent. Why is Keith jumping forward? You're going to have to take my word for this. Three things. Number one, you can rebut the business judgment rule by showing a failure to consider reasonably available information, right? That's not an intent issue. That's just a due care negligence issue. The other one I mentioned is usurping a corporate opportunity. Again, that doesn't require specific intent. In fact, a lot of times usurping a corporate opportunity arises just from ignorance. People just think, oh, of course I'm allowed to take that opportunity. They're wrong. They're just stupid about what their fiduciary duties are. But that is a very common fact pattern that underlies an oppression claim. And now we have this scenario, well, gee, maybe in order to show that that usurpation was oppressive, now I have to show specific intent. You also have the interested transaction statute, which puts the burden on the defendant to show that the transaction was entirely fair. Again, interested transactions are fertile ground for an oppression claim. But what's the rule now? If I sue you for oppression because you enter into an interested transaction, do you have to show that's entirely fair? Or do I have to show that you committed that interested transaction with the intent to oppress me? I don't know what the answer is on that. You have two statutes now that go against each other. I think all of this could have been avoided just by having straightforward business judgment analysis. You can say, business judgment rule applies, it's no longer a strict liability statute, and we don't need to worry about intent. Any questions? All right.
All right, David, thank you very much.
Now
Sorry, no power screen. I knew by going last that all the smart things already would have been said, so I'm just going to have to do my best to pick up the little crumbs that were left along the trail. And so I sat back there just writing notes to myself with subjects to cover. Now, if you were one of the 3 people who was here for the seminar last year, you know I opened by reading a paragraph in a case I wrote called Moyer versus Mantese, where they created this insane LLC called Caveman Holdings. And the whole point of it was to essentially shield from creditors all the assets of one of the 2 members. And everybody found it somewhat amusing that I referred to all the creditors with evolved hands with opposable thumbs trying to get their hands on this nonsense. This year we're going to do something different. I decided thematically what to call the remarks this year would be of walruses and basketball. And here's why. If you're a follower of Lewis Carroll, you know the song, the poem, The Walrus and the Carpenter. The time has come, the walrus said, to speak of many things, of sailing ships and sealing wax, of cabbages and kings. This is just a hodgepodge. This is a melange. And so think of it that way. And the basketball stuff, I'm on fumes right now. I was at the Michigan State Duke debacle last night, so I got back really late and then I had to get up and drop my kids off. So I want you to ask lots of questions so I don't fall asleep during my own remarks. It'd be very helpful if I just get startled from time to time. So please, feel free to jump in because this is going to be a bit disjointed. Now, first of all, I want to thank Mark Rossman, who has made quite a commitment to try to bring this program to West Michigan. We in West Michigan always complain that everything's on the other side of the state. As a matter of fact, I'm going over there tomorrow to speak on Friday. I'm going back to speak at the Wayne County Bench Bar Conference the following Wednesday. This is how it goes. So when they come here, we've got to be supportive. And Mark, thank you very much for being here. We really appreciate it. And I promise, every time you come back, we will increase tenfold the attendance.
The third and the fourth annual.
Right, it's like the king who offered the guy
I won't
who
stop
invented chess. Eventually, it's just going to go completely out of control. We'll have so many people here who can't put up with us. I want to thank Forts Legal, too. Sean and everybody else here did a wonderful job of putting this on, so thank you very much. Just coincidentally, they've had the last two events catered by two of my favorite places in the area, 40 Acres and then Carolina. So I'm very pleased. They get to eat something I would have gone out and paid for just for free. So thank you very much. Now, let me, instead of starting with what you're expecting, a fastball, start with a slow curve. I'm going to go completely out of the box here and tell you that on January 1, 2020, new discovery rules are going into effect. I was on the committee. I wrote a lot of the language, so don't say we're stupid, at least not in my presence. And I brought a little outline for everybody if you want. It's only 4 pages. This is, if I count this is the 19th time I've talked about these rules. So this is evolved, and if you want to know what the new rules say, in 4 pages, that's everything you need. Please pass those around. All right. Now, more to the point of why we're here, which is talking about litigating oppression cases. I'm going to refer on a couple of occasions to Paul McCarthy because he appears in front of me on a regular basis, and every single time he does, I learn something. I learned, for example, what big-ass fans is when he was trying to identify the most outrageous expenditures run through a company in a case. One of the things that he taught me that I always try to tell people when they have these cases is if you want to get documents and you're somebody who is being oppressed, there are 2 different avenues to do it. You have statutory rights to disclosure and you have the discovery process. And if you put those 2 things together, it's amazing how much you can get. So I know Paul's had a couple of occasions in front of me where people were arguing that something was outside the scope of allowable discovery, and his response was, so what? It's a statutory right anyway, just give it up. And so I want you to think broadly about that because particularly when you're on the bottom side of being oppressed, there are lots of rights you have to get your hands on documents because first and foremost, you need to figure out what the heck's even going on. When you're being oppressed, people don't tell you a whole lot. And so you want to use every tool at your disposal to get your hands on all the papers you need. All right, now, the next thing I want to talk about as far as oppression, you'll see this is kind of what came up during the course of the discussion tonight. 50-50 ownership. I don't know why anybody does it. If I were writing state law, and I am the chair of the legislative committee for Michigan judges, so someday I may take a run at this, both the Limited Liability Company Act and the Business Corporation Act should say that you have to give at least 2% to a wise and level-headed person. But no one ever does that. Of course, everybody dives right in thinking, we're good friends. What could ever go wrong? In the same way that people dive into marriages, and then I was in the family division for 4 years, and I see people trying to kill each other, and I think, you know, you really ought to think of some of these things at the front end. Nobody ever does. But in the 50-50 ownership cases, particularly when we're dealing with oppression, to me, one of the hardest questions to answer is whether you actually have somebody who is in a position to oppress somebody else. In 50-50 situations, sometimes they do have the ability to oppress, sometimes they don't. And if truly they've divided up management responsibilities and compensation and everything you can imagine as equally as can be divided up, it's pretty hard to argue that there's any sustainable oppression claim at all. On the other hand, Kingman Holdings is a good example. Moyer versus Mantese is actually the name. That was a case where essentially it was a member-managed limited liability company, and one member had all control of everything. And so the member who was the manager made every single decision and could not be removed from that position or divested of that unilateral authority without a majority vote. And of course, he had 50%, and so nobody ever could muster a majority vote against him. Now, it all worked perfectly as long as the two brothers were conspiring to keep the creditors away from the brother who was being oppressed but not complaining about it. But once the brother was being oppressed, got forced into bankruptcy and the trustee took over the claim, then it looked like a real shareholder oppression claim. And from that perspective, it was patently obvious that even though they were in a strict 50-50 relationship in the limited liability company, there's no doubt that his brother had control in every meaningful sense. And I was willing to say, despite the 50-50 ownership equilibrium, that there could be and was in fact oppression under the circumstances. So, yes?
So if you have a 50-50, let's say,
Yep.
and you divide up the management responsibilities,
Yep.
and then all of a sudden there's a breakdown of the relationship, which is, of course, commonality of all these cases, and one 50% owner starts grabbing pieces of the other person's management. Do you think that's material in whether or not?
Yeah, you can get there. I mean, it's really a sliding scale analysis in my mind. So the fact that they're 50-50 doesn't mean that one can't oppress the other, but it doesn't mean that one is oppressing the other just simply because they have control. And so in those circumstances, what I've done is I've looked at exactly that. If there's some way that one can essentially wrest control of all management from the other, then you have, at least in my view, a textbook situation where you can have oppression.
And it seems almost like third grade to me, where partner A starts saying, well, I'm going to take that, I'm going to take that, I'm going to take that.
Yep.
The only response that partner B can have is, well, I'll take this and that and the other.
Right, well, that's exactly
And
right.
all of a sudden you broke it down here in the sandbox, right?
Right, right, and that's when everybody comes running into court asking for a TRO. Always on an ex parte basis too, even if both of them have lawyers.
Just to tag on that, the kid stole the block, okay? He took it.
Right.
Okay, he doesn't have a right to it.
No.
He took it.
Right.
Can he come in and does he have an oppression? The guy took control. He
Right.
has,
Yes.
They have control.
Yes.
They don't deserve control, but they have it.
Yes, yes. I think in that case, not only do you have sufficient control so that the other one can assert oppression, but you have a very active oppression itself in the process of getting control. So, I mean, I don't mean to conflate two parts of the analysis, but they should be conflated in that sense, at least in the circumstance you identify. So in 50-50 cases, you really do have to think through, and I'm always willing to be persuaded that somebody is either in control or not in control, so there either can be or cannot be an oppression claim. And I think this is one of those areas where some of us in the business court struggle a bit, and you need to educate us on that, because there tends to be this almost binary approach to it. If it's 50-50, there can't be oppression. But that's not so at all. And the hypothetical you laid out, Paul, is exactly why that's so. All right, let me just say a few words about the statutory amendments which are in the works. And I don't know where we're going with this. I was asked to be on the committee. I respectfully declined to ask to bird dog the committee because I wanted to see what was going on. I was swamped at the time. And I thought there were way too many smart people on it already, and they didn't need me for anything. But I'll say this. I think, and maybe some of the members, the active members of the committee can fill us in, but there is now perhaps some amount of hesitancy about going forward because the devil you know is better than the devil you don't know. And we all think we're in a pretty good place now in analysis of suppression claims. So I'm not sure what's going to come of that, but I'd sure like somebody to put their hand up and tell me where we're going. Because if there are going to be proposed statutory amendments, I'm all for getting behind them in my capacity to speak for the Michigan Judges Association and try to get everybody on board. If they're not coming, that's fine too, because I like the world in which we live now. Paul?
We were looking at fair value. I'm not sure it's all concluded, but the conclusion was, as you say, it's fine.
Okay.
It's not perfect, but it's fine.
Right. I mean, before Matagula versus Cobb and some of the other cases filled in some of the details, it really was a bit murky. But what I like about the statute now is, particularly on the remedy side, there's so much flexibility built into it. And boy, be careful what you wish for when the legislature starts poking around it, and you give yourself a straitjacket. and then it's awfully hard to operate. I mean, my sense of it is, I'm seeing really good arguments in oppression cases. I don't think there's any lack of creativity, and I think judges are at least fairly receptive to that. And so if you've got a world like that, first of all, it's great for lawyers who are really skilled, because you can litigate rings around people and get all sorts of good outcomes, no matter which side of the case you're on. And second of all, we really can develop our own sort of common law jurisprudence as we go under the statutes in order to work out what we think are the rules of engagement. I mean, it's a workable fabric now, and I'm actually relieved to hear that we're not going to go forward. So I don't want you to think that I'm inhibiting you from going forward, but I like where you've landed. I'm glad to hear that.
So I have a question about
Yeah,
that.
sure, of course, Andy.
So, I don't practice on the east side of the state really very much anymore, but so are we seeing any distinction in decision-making on the east side of the state when we compare it to what's happening in West Michigan?
Well, that's a really good question.
You talked about developing common law.
Right.
My question is your common law going to be different than what it is in Oakland County?
Yeah, that's a good question. And let me jump ahead to one of the other points I was going to make, because I want to talk about the business courts in Michigan in general. The first thing I'll say is that I'm pleased to report that people seem to be voting with their feet. We're getting a lot more cases now, and you can see it reflected in the business court dockets. I mean, I always describe what we do as being in a competitive industry, because people can go to federal court, you know, if they never want to get to talk to the judge, but get well-reasoned opinions. You can go arbitrate if you want, which once was cheap and quick, but now it's neither cheap nor quick. You can come to us, or you can go to a county where you just blind draw it. And my sense of it is that there is some increasing level of confidence in the business courts that's bringing more business to the business courts. Having said that, I think we're all fairly sensitive to the fact that it matters a great deal who's deciding the cases. And again, people vote with their feet, because in a lot of business court cases, I'm sure you know, you can lay venue almost anywhere. And so we talk all the time about how to deal with judge shopping. And there are lots of ways to try to deal with it, but that too is a concern. And I try to be sensitive to what the other judges are doing. I try to read some of their opinions. Sometimes you get some fairly consistent patterns with some of them where they're really relying heavily on law clerks to do the writing. Somebody's views might change from year to year to year. Well, I had one law clerk and then a new law clerk came in with a different view of things. I mean, I write all my own opinions. And so unless I somehow become schizophrenic or senile, you're going to get the same thing every day from me. So, but I don't know about that. The problem is I'm stuck inside the four walls of my own courtroom, and I don't know what's going on everywhere else. I try my best. We do quarterly. I read stuff, but maybe some of the rest of you know.
I don't know if you're hearing, you know, someone from, let's say, the east side state before you raising, well, this judge over here in Oakland County says this. Have you seen much of that at this point?
No, you know, I'm not getting a lot of cases cited to me from my colleagues, and I wish I got more. I'm not insisting on it, obviously. It's not binding. It's like Queen's Bench or something. That's the best you can do. And they abolished Queen's Bench in, what, 1875?
I'm just trying to create some predictability to this.
Right. Well, and I don't blame you for that. I mean, you don't want it to be a situation where everybody's a major league umpire and they have their own strike zone, and what's a strike in Kent County is a ball in Oakland County. I mean, we are attuned to that concern.
Right.
I mean, that can't get us anywhere. But one of the problems we're having, and this came up at the Business Law Institute, is the Court of Appeals, for whatever reason, seems especially hesitant to publish in this area. And so we're just not getting the law nailed down very much. And one of the things about Franks versus Franks is it's almost so tentative, it's apologetic. I mean, we're not, I mean, I think about Paul's head exploding as he's reading the place where they say, well, fair value might mean fair market value, or it might not. It depends what you want to do. Now, if you've studied valuation at all, there's a big difference between fair value and fair market value. And I was going to refer you to one of my opinions that I wrote, no pride of authorship, but it's a case called Niewick that just got affirmed by the Court of Appeals on October 1st, docket number 343088.
Reported or unreported?
Unpublished, of course. Yeah, unfortunately unpublished. And my opinion goes into a lot of fairly detailed valuation with charts and whatnot. And the Court of Appeals, I think, wrote a fairly solid opinion, and I don't know why they didn't publish it. I'm puzzled. One of the problems with Frank's, I think, is that, no offense to Judge Stutzman, who I like immensely, but it came up on a very odd record. And I think there were procedurally some major problems that led to some of the perhaps aberrant analysis that you'll see in the Court of Appeals opinion. But at the end of the day, I think we're all struggling because we're just not getting the law pinned down in this area. And I wish we were. I mean, you know, a case like Menegola versus Todd comes out and nobody asks questions about it anymore. The Supreme Court said it, we're good. We're done. Same thing with conversion, you know. The lottery ticket of the business docket. Everybody pleads statutory conversion. You can get treble damages and attorney fees, so why not throw it in there? Even if it doesn't apply at all. Unfortunately, you know, now we know what the law is on conversion. We don't have to guess about it. So somebody was going to say something. Nope. Okay. Well, let me keep going. I want to see where I am here. I did want to say something about valuation because I joke about the difference between fair value and fair market value being indistinguishable or not in the court's preference. You really do need to teach yourself a little valuation if you're going to do this kind of work. I suspect most of you know it reasonably well. I go all the time to conferences of the National Association of Certified Valuators and Analysts. I speak there all the time because this stuff matters. And one of the difficulties that we have when I go to these conferences is that you get an awful lot of experts, but they're not talking to enough judges, and so you've got to be in a position to educate us so we don't do stupid things. I don't want to court appoint an expert and add another layer of cost when you each have a valuation expert. The problem with valuation experts is, you know, the right answer is somewhere in this band, and one expert's here and the other expert's here. Well, that doesn't help. So, at least as far as I can tell, to the extent that you can get yourself up to speed, you can be incredibly persuasive in that area because frankly it's an area that scares a lot of judges. All right, now, I talked a little bit about the business courts as common law courts, and so I want to talk a little bit more about publishing opinions and my philosophy and how we need to do this. I have more than 500 opinions out there now in a searchable database. I've written every one myself, and I think it's not just a statutory mandate for business court judges to write. It's an imperative of what we're trying to do here. I mean, you know, we don't have the great vanity press that federal trial court judges do. I mean, they've got Fed Sup. I don't know how volume I can publish my stuff in, but at least I can put it out there, and the Supreme Court's trying to get it out there. And so we're doing the best we can to really work at it. I know there's been a fair bit of criticism about some judges and even some courts that aren't writing enough. Understand, the Chief Justice cares deeply about this, and she's called me at least half a dozen times with the same basic question. How come you write all the time and a lot of people don't write at all? And I know they're working on trying to incentivize that, to provide resources for judges, to essentially keep track of the opinions, to require minimums for publication. And frankly, this is our endeavor, all of us, together, collectively. You have to help us write better opinions, and we have to write more opinions, because if we're not going to get binding decisions from the Court of Appeals, we're going to have to work on developing our common law as best as we can. And oppression, I think, is one of those great areas where there's a lot of room to maneuver, and if we give you enough guidance, you should know what's a ball and what's a strike, and we won't have to spend a lot of time thinking around these stuff. Okay, let me just say this, because I was struck by a suggestion Paul made about bifurcation in oppression cases. My general philosophy about bifurcation, because I've bought into it a couple times when I shouldn't have, and I often joke that I hate bifurcation so much I won't even cut sandwiches in half anymore. But in the right case, bifurcation is incredibly intelligent, and the right case is one where the expert costs don't get layered on until you get to damages or remedy, and oppression is precisely that kind of case. You want to get me to buy into bifurcation so we get liability cleaned up first, and then and only then do we get around to the question of remedy or damages? Oppression claims are the perfect claims to make that sort of request. Not saying you can sell it to everybody, not saying you can sell it to a lot of people, but the more I think about it, the more I think that makes a tremendous amount of sense. All right, let me close, because I really am determined to get you out of here on time, or nearly on time. I guess it's after 8 o'clock. I want to talk about a really interesting point that came up earlier, and that's the partnership trap. This whole notion that we clearly define when we formed an organization that's a limited liability company. And although we have presumptions that lead us to the corporate form as well, like corporation by estoppel or de facto incorporation, incorporation is easy enough, so you shouldn't screw it up anyway. Partnership is sort of like love. You can fall into it without having any intention at the front end of ever doing it. And so you've got to be very, very careful how you run your operation. I put out an opinion on December 11th of 2018 in a case called Tedford versus Rhoades. T-E-D-F-O-R-D versus R-O-O-D-V-O-E-T-S. You can find it a couple different places. Anyway, here's the theory in Tedford versus Rhoades. I mean, it almost made my head explode, but we had to have a trial to settle the question. And that's exactly the point I think that you two were making, that you can wind up in this partnership rep, but the only way out is to go to trial. Fortunately, it was a bench trial, and I ruled that it was not a partnership. But what happened was this. There are two people. One guy's got a clean record, but he doesn't understand the industry. The other guy's got a bad criminal record, and he understands the industry perfectly. They form this operation. The guy with the clean record goes out and forms an LLC and gets all the loans, and the guy who does the shop work, and they're making money hand over fist. And so they decide to create their own LLC to manage the property, Rooted Investments, which amused me. Just put the two names together and you get Rooted. So they knew how to form an LLC because they formed an LLC. But at some point, the guy with the bad record, I know this is shocking, has a terrible temper and he blows up and storms out. And there they are. And they have this really profitable business and the whole thing's just going under now. And what are you going to do about it? So the guy who had formed the LLC to own and manage the property, but wasn't part of the LLC that was the company itself, the guts of the company, says, guess what? We're partners. And the other guy says, the heck we can't be partners, I got an LLC. He said, no, I'm not partners with you. I'm partners with your LLC. So I did a whole bunch of research on it, and there's nothing that forecloses an argument, and there are a couple of Court of Appeals cases that seem to suggest that even an individual can form a partnership with an LLC. Now, we had a trial, and once I heard all the evidence, and I could write behind the protection of all the discretion afforded to findings and facts, conclusions, and law and good, I essentially said, this is the most insane thing I've ever seen in my life. I mean, these guys obviously know how to form an LLC. They did it. You can't possibly argue that it's a partnership, but the problem on the back side of it, if you read Biker versus Madison, everything that goes with it, everything that follows from it, is that absolutely insane theory still might fly on the right facts. And so the difficulty of it is, I think, that you always have to be sensitive to whether you are, in effect, falling into love, creating a partnership where you have no interest whatsoever in being partners with somebody else. And so just word to the wise on that. I'm glad somebody brought that point up, because before I had Tedford versus Rhoades, I would have just laughed at that argument. But once I went through and did all the research, I realized, oh my gosh, you can wind up being partners even though neither one of you really ever actually intended to be a partner. So I'll offer that as my last thought. I'm happy to take lots of questions or no questions, depending on what you want to do. I'll stay around if you want to talk afterwards. But thank you very much, everybody, for being here. It takes a rare person to come in and spend more than 2 hours sitting here talking about arcane corporate propositions. But I want to thank you not just for being here, but for those of you who are serving on the committee on oppression that's reviewing the statutory schemes. You are really doing the most important work out there, because we are at this moment, and maybe it's due to term limits because you can slip a lot of stuff through the legislature, or maybe it's just because we're making good proposals, but where the business law section really does seem to be able to drive the legislative agenda when we care to do it. So thanks very much, I really appreciate it.
Thank you everyone for coming tonight, and thank you for all the speakers. And if you hadn't have enough of this, we're doing it again in January 15th in Detroit.